Wait.
The meeting of the Commission on
This
State
conference
Mandates.
is being recorded.
Welcome to our hybrid meeting. For those participating in person, I have some housekeeping information. On the table near the wall are paper copies of the meeting notice and agenda, new filings, proposed consent calendar, and witness list. The electronic public hearing binder is also located there on a laptop. When called up for an item, the parties and witnesses will please sit at the witness table. The restrooms are located out the door and down the hallway to the right. The women's room is across the open atrium. The key for both restrooms is on the table as you exit the conference room. Finally, please take note of the emergency exits in the room. For those participating remotely, the materials for today's meeting, including the notice, agenda, proposed consent calendar, and witness list, are all available on the Commission's website, www.csm.ca.gov, under the Hearings tab. When being sworn in at the beginning of a hearing, and when called for an item, the parties and witnesses will please turn on their video and unmute their microphone. At the conclusion of the item, please turn off the video and mute the microphone. In the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. Finally, please remember to speak slowly and accurately for the benefit of the court reporter and an accurate transcript of the hearing. On October 25th, 2024, the Commission met in closed executive session to confer on personnel matters pursuant to Government Code Section 11126A1. By a vote of 7-0, the Commission voted to appoint Ms. Juliana Moore as the Commission's new Executive Director with a starting salary of $18,310 per month. After the meeting, Commission management sent her the offer and she accepted. And then the Governor's Office approved the appointment effective November 12th, 2024. Please join me in welcoming our new Executive Director, Juliana Moore. Ms. Moore has been an attorney for 32 years and has been in public service for approximately 19 years, practicing public law. She has served as an acting executive director and senior commission counsel here at the Commission, and deputy assistant county counsel at the County of Kings. She has approximately 16 years of state mandate law experience when representing local governments before the Commission and working here at the Commission for the past nearly 5 years. In her prior state mandate experience representing local government, she filed test claims, proposed parameters and guidelines, and incorrect reduction claims on approximately 21 state-mandated local programs. Welcome, Executive Director Moore. Juliana, will you please call the roll?
My pleasure. Ms. Peralt and Ms. Nash informed the Commission staff that they are unable to attend this hearing. Mr. Adams.
Here.
Ms. Clark. Ms. Clark.
Here.
Ms. Gallegos.
Here.
Here. Ms. Green-Ross.
Here.
Mr. Polland.
William Polland here as designee of Vice Chair, State Treasurer Fiona Moe. Present. Present here.
Thank you.
Next is item 1. Are there any objections to or additional corrections of the September 27, 2024 minutes? All right, hearing none from members of the board. Is there any public comment on this item?
Mr. Vice Chair, I do not see any public comments. Sorry.
Thank you. Any questions from the members? Hearing none, is there any further discussion?
Mr. Chairman, I would move approval.
Okay, so hearing no further discussion, we have a motion for approval.
Mr. Evans.
And a second from Ms. Gallegos. Okay. Please take the vote.
Mr. Adams.
Aye.
Ms. Clark.
Aye.
Ms. Gallegos.
Unmute or just say?
Just say it.
Just aye.
Ms. Green Ross.
Aye.
Mr. Polland.
Aye. The motion carried. Thank you.
And now we will take up public comment for matters not on the agenda. Please note that the commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on the matters that are on the agenda as they are taken up.
Is there any public comment?
There are no public comments online, Mr. Chair.
Thank you, and I'm seeing none in the room. So with no public comment, we will move to the next item.
Next is the proposed consent calendar. Item 5 is proposed for consent.
Are there any objections to the proposed consent calendar from the members or from any members of the public? Okay, hearing nothing from any members or members of the public, is there a motion to adopt the proposed consent calendar?
Move to adopt.
All right, thank you, Ms. Ferris. And second, thank you.
I'm sorry,
So we
this is
have
the court
a-
reporter. This is the court reporter. That was too fast and I could not tell who made the motion or who seconded.
Karen Green Ross made the.
And there's an echo now.
Karen Green Ross made the motion.
Go ahead. Don't unmute when you speak.
Oh, Karen Green Ross, made the motion. Shannon Clark made the second.
Thank you.
Okay, so we have a motion and a second. Are you ready for the vote? Is there any further discussion needed? Hearing no necessity for further discussion, Juliana, please take the vote.
Mr. Adams.
Aye.
Ms. Clark.
Aye.
Ms. Gallegos. Aye. Ms. Green Ross.
Aye.
Mr. Polland.
Aye.
And that motion carried. Let's move to the swearing in. Will the parties and witnesses for item 3 participating remotely, please be sure that both your first and last names are listed on your Zoom window for the benefit of the court reporter. Turn on your video and unmute your microphone. And all parties and witnesses, please rise. Will the parties and witnesses for item 3 please state your names for the record?
George Landon, Deputy Superintendent, Business Services for Hesperia Unified.
Arthur Palkowitz, attorney for the claimant.
Jessica Deichman for Department of Finance.
Alex Anaya with the Department of Finance.
Thank you. Do you solemnly swear or affirm that the testimony which you are about to give is true and correct, based on your personal knowledge, information, or beliefs?
Yes.
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 Thank you. Next is item 3. Senior Commission Counsel Eric Feller will please present a proposed decision on heating, ventilation, and air conditioning HVAC program, 23TC01. At this time, we invite the parties and witnesses for item 3 participating remotely to please turn on your video and unmute your microphone.
Good morning. The test claim statute generally requires school districts to ensure their HVAC systems provide healthy indoor air quality. Statute requires schools to either ensure that their HVAC systems meet the current minimum ventilation rates in the Energy Code, or ensure they meet the minimum rates in effect when the permit to install the system was issued, and document the system's inability to meet the current minimum rates. This requirement is new only for schools with HVAC systems approved for installation before January 1, 2020. The claimant has not requested reimbursement for this and has provided no evidence of cost mandated by the state to comply. This claim statute also requires schools to install MERV 13 or higher filters if feasible, or install the highest filtration the school deems feasible without reducing the lifespan or performance of the system. Claimant requests reimbursement to install MERV 13 filters in all of its schools' HVAC systems since January 1, 2023. But installing MERV 13 filters is not a new program or higher level of service to the extent a school received a permit to install a new system after January 1, 2020, because the Energy Code already required MERV 13 for those systems. Also, the MERV 13 requirement is not new if there was a COVID-19 outbreak in the school, because they were already required to have MERV 13 filtration when the test claim statute became effective in January 1st, 2023. There's no evidence in the record of any costs mandated by the state to perform the one-time activity to install MERV 13 or higher filtration, or install filters that achieve the highest feasible MERV level without significantly reducing the lifespan or performance of the existing system. In schools that have HVAC systems approved for installation before January 1, 2020, staff recommends the Commission adopt the proposed decision to deny the test claim and authorize staff to make any technical non-substantive changes to the proposed decision following the hearing.
Thank you. Parties and witnesses, please state your names for the record.
Good morning, Arthur Palkowitz on behalf of the claimant.
George Landon, Deputy Superintendent for Sperry Unified.
Jessica Deichman for Department of Finance.
Alex Anaya for the Department of Finance.
All right, thank you. Dr. Landon, Mr. Palkowitz for the claimant, would you like to begin?
Would it be okay if I start as a claimant representative?
I have no objection.
Thank you. Thank you for the opportunity to address the Commission. This test claim was filed based on the new Education Code section 17661C. We are not in disagreement, or rather we are in agreement with the Commission's analysis of the other sections regarding 17661. However, 17661C to the Education Code is a new requirement. It is a new statute. That statute requires that school districts install MERV 13 infiltration systems. These are high-level infiltration systems that really came about due to the fires and the lack of clean air throughout the schools throughout California. This is a new section. This is not an old section or a previous section of the Ed Code. So there is a presumption that this is a new law, as the legislature doesn't pass bills that are already in effect. As a result of this new law, the MERV 13 air filters were installed in the school system for the claimant. These filters are more intense filters than the previous. They require more labor, more manpower, and they are more costly. We submitted these costs with our test claim, substantiating the increased costs that came about as a result of this statute. In our comments that we filed, we supported that this test claim statute AB 2232, effective January 1st, 2023, that included the Ed Code section 17661C, was a new statute. Though there were a previous Assembly bill, they did not, Assembly Bill 841 passed in 2020, though they encouraged MERV 13 filters, it wasn't mandated to that. We believe that this, as a result, these are new costs, and this is a reimbursable mandate. If there are, at this point, we're ready to respond to any questions you may have, including Dr. Landon is present as a representative of the district.
Unless the board members have questions now, I'd propose we listen to Mr. Anaya and Ms. Deichman and then take questions for both at the same time. Is that acceptable? Okay, so nothing further, Mr. Palkowitz or Dr. Landon?
We would just like an opportunity to respond if that's appropriate.
Okay. All right, so Mr. Anaya and Ms. Deichman for the Department of Finance, do you have any comments?
Hi, Alex Anaya with the Department of Finance. No additional comments to add besides those submitted in February in support with staff recommendations.
No additional
And here to
comments from me either.
And yeah,
Thank you.
here to answer any questions as well.
Then
This is the court reporter. There was some crosstalk there. I did not understand Ms. Deitch.
I just said no additional comments from me either. Thank you.
Thank you.
Okay, next we'll take any public comment there may be.
I actually.
Oh, then we'll go to the board after the public.
There are no online public comments, Mr. Chair.
Hearing no public comment, Ms. Gallegos.
Yeah, I would just like to hear staff response to, was it Mr. Palkowitz's claim that there was not a mandate, but only an encouragement of the former AB 841, and that this is a new code that should be submitted under the test type.
So, sure, when we looked at the, all the prior law, including the energy code, which is part of the building code, building standards code, the energy code for HVAC systems required MERV 13 already for non-residential buildings, including schools. They actually have a, and the table 120A that's in the energy code lists classrooms and schools. So that it's applied to schools at least since the 2016 energy code, which was effective January 1, 2020. So the analysis says that for the systems that were approved after January 1, 2020, this is not a new program or higher level of service for any HVAC systems that were approved after that date. Same with the COVID outbreaks. There was a regulation passed in 2020, and those schools were also required to have MERV 13 filtration, or as high as their systems could handle, without shortening the lifespan of the system. So it's not new for systems approved for installation after January 1, 2020.
Thank you.
Any other members of the board with questions? Okay, I do have some follow-up. So, Mr. Kralkowitz, could you describe the circumstances under which these filters were installed?
Well, I think it'd be best that Dr. Landon describe that. And what we are pertaining to is January 1, 2023, after the statute was enacted, rather in effect.
Were the filters, though, installed in connection with a permit obtained for an HVAC system upgrade, or were the filters simply installed just as part of regular maintenance and changing filters, or something else? So,
No, it wasn't part of regular maintenance.
Mr. Palkowitz, would you mind if I interjected there?
Of course, thank you.
Mr. Chair, what our district chose to do that upon receiving what I call the second phase of ESSER dollars, and knowing that we were in the midst of the COVID pandemic situation, we did a district-wide replacement of our HVAC systems, and we received an architect because our schools range in age 15 years to 60 plus years of age. And structurally, some of our schools wouldn't be able to maintain the weight of the rooftops and that, and knowing that the pandemic kind of escalated the situation, we did go through the DSA process, Division of State Architect, and received that permitting process and went out to bid to find those contractors to remove and replace with new systems that did carry the MERV 13 filter, as we're well aware that it's a much denser type filter, which captures the particulate matter much quicker and needs to be replaced more often than a MERV 8 type filter.
So then, Mr. Feller, does that information change your analysis at all?
Well, the reason that we wrote the analysis the way we did is we didn't have any evidence of HVAC systems installed prior to January 1, 2020. So to the extent that the school puts evidence in the record that they have those, that would change the analysis.
Okay, but did I understand either Mr. Brukowitz or Mr. London correctly that this work was all done sometime after 1/1/2020?
Yes.
Ms. Deichman or Mr. Anaya, do you have any follow-up comments?
Alex and I have no comments at this time.
Members of the board, any comments?
I have a question.
Please.
The evidence of increased costs, or was it expected that the school district had to have a finding of a COVID outbreak?
Let me respond to that. Under the COVID regulations, if there was a COVID outbreak, meaning that 3 or more employees tested positive for COVID, then under the law, they had to replace their filtering systems with MERV 13 or the highest filtering system available. And so those schools were already required by law to do that, which is the same requirement imposed by 17661 subdivision C.
And that applied to all workplaces across the board.
Yeah.
So, yeah, that's.
So no finding was required, but it was required by law.
But that was for, if I may add, that was for schools that had an outbreak in our case.
Correct.
And the outbreak was defined in the proposed decision as 3 or more employees exposed at a work site during any 14-day period. And I don't believe that was the case at the claimant.
The other key part, however, as you've already discussed, is that it's not a new requirement to install MERV 13 filters. If you received your permit for an HVAC installation after January 1, 2020. And Dr. Landon and his declaration both indicate that they replaced their systems in beginning 2021. So there's no new requirement there. The school districts have been required to comply with the Energy Code since 1987, actually. So, and the Energy Code has changed, but it definitely beginning January 1, 2020, those same requirements were there.
But it sounds like there were some HVAC systems that could not, it had to be replaced because of the weight.
That might be true, except they have no evidence that they have any old HVAC systems beginning with the effective date of this test claim statute and the beginning period of reimbursement of January 1, 2023. And you need evidence to show that.
And is that true? There's no evidence, Mr. Popwitz?
We submitted plans, but I don't know if they address what's being raised now.
You would need to show that you had HVAC systems with a permit approved before January 1, 2020.
Okay, so in our claimant's supporting documents, we have approval of plans. I'm not sure where that comes from, that requirement.
Brukowitz or Dr. Landon?
Yes.
What is the increased weight of the MERV 13 filters versus the other filters? We're talking about additional loads on the roof at some point. Is that additional load due to a new HVAC system or due to these filters themselves?
No, it's due to the load of the HVAC system on the rooftop.
Any other questions from members of the board at this point? All right, anyone have any further discussion? All right, hearing none, can I have a motion? Anyone?
would it be a motion to approve the recommendation of staff?
Motion to approve staff's recommendation.
I'll move.
correct.
I'll so move.
And does anyone have a second?
I'll second.
Thank you. We have a motion.
This is the court
and
reporter. I could not tell who seconded.
Ms. Greenross.
Seconded it. I didn't use my voice, so there wouldn't be an echo, sorry.
Can you just speak up a little bit more, maybe?
So did you get that was Ms. Greenross?
Yes, thank you.
Court reporter. So we have a motion and a second. Ms. Moore, please take roll if you could.
Mr. Adams?
Aye.
Ms. Clark?
Aye.
Ms. Gallegos?
Aye.
Ms. Green Ross?
Aye.
Mr. Polland?
Aye. Motion's carried.
We now ask the presenters participating remotely for item 3 to please turn off their video and mute their microphones. Item 4 is reserved for county applications for a finding of significant financial distress or SB 1033 applications. No SB 1033 applications have been filed. Item 6 is the legislative update. There is nothing new to report. Next, Chief Legal Counsel Camille Shelton, please present item 7, the Chief Legal Counsel report.
Good morning. We just have one recent decision issued by the Sacramento County Superior Court on the City of San Diego versus Commission on State Mandates case, dealing with the remand of lead sampling in schools. There, the Superior Court found that the city was practically compelled and thus mandated by the state to comply with the test claim permit amendment. We have no further litigation cases pending on the calendar, and that's all I have today.
Thank you, Camille. Item 8 is the Executive Director report. Associate Governmental Program Analyst Steve Garcia will please turn on his video and unmute his microphone for his introduction to the Commission. It is my pleasure to introduce Steve Garcia, our new AGPA procurement. Steve earned his Master of Business Administration and his Bachelor of Business Administration in Supply Chain Systems from the University of Massachusetts Global and his Associates of Applied Science in Logistics from Community College of the Air Force. Steve comes to us as a purchasing analyst from the California Department of Food and Agriculture. Prior to that, he worked at Caltrans, first as a procurement specialist and then as a policy analyst. Earlier in his career, Steve served in the Air Force and was stationed at Travis Air Force Base, after which he worked at Raytheon as a contract and warranty associate. Today is Steve's first day at the Commission. Welcome to the Commission, Steve.
Thank you very much. Happy to be here. Nice to meet you all.
Thank you for joining us this morning. Please turn off your video and mute your microphone. I have 2 information items. Our workload. According to the caseload, there are 37 pending test claims, 35 of which are regarding stormwater NPDES permits. There are 1 parameters and guidelines, 6 statewide cost estimates, and no IRCs pending. Commission staff expects to complete all currently pending test claims by approximately the December 2027 Commission meeting, depending on staffing and other workload. Regarding tentative agenda items, please check the tentative agenda items on the Executive Director's report for upcoming items or access the pending caseload documents on the Commission's website, which are updated at least bi-monthly. Draft proposed decisions on all test claims and IRC matters are served and posted for review and comment at least 8 weeks prior to the hearing date, and a proposed decision approximately 2 weeks before the hearing. And that concludes my report.
All right. Thank you. Next, the Commission will meet in closed executive section pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed in the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The Commission will also confer on personnel matters pursuant to Government Code Section 11126A1. We will reconvene in open session in approximately 15 minutes.
All should have a closed session.
Yeah. We exit out of this?
Yeah. Yes.
Oh, in the old days, I could just walk out of the room.
I know. You can leave. Collins, you're back.
Okay. All right. Hello again, everybody. The commission met in closed executive session pursuant to Government Code Section 11126E. Confer with and receive advice from legal counsel for consideration and action as necessary and appropriate on the pending litigation listed in the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The Commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With no further business to discuss, I will entertain a motion to adjourn.
So moved.
All right, so we have I think, a motion from Ms. Gagos, and I'll take that as a second from Ms. Clark. Okay, so we have a motion and a second. Juliana, please take the roll call vote.
My pleasure. Mr. Adams?
Aye.
Ms. Clark?
Aye.
Ms. Gallegos?
Aye.
Ms. Greenrock?
Aye.
Mr. Polland?
Aye. Motion carried. The meeting is adjourned. Thank you, everybody.
Thank you.